So I want to cover some of the basics of the California legislative process or how a bill becomes law in California. For those not fully acquainted with the California legislative process, new laws that come from bills are called statutes, and those are enacted by the California legislature through the use of a bill and generally signed by the governor in order to become a law or a statute. In fact, the California Constitution says that the legislature shall make no law except by statute and enact no statute except by bill. Of course, the legislature can not only add new laws, but they can amend or repeal existing statutes as well. Now, whether a statute is added, amended, or repealed, that process must be done by a bill that again has to pass the legislature and be signed by the governor, or he or she can allow it to become law without a signature. According to the California legislature, the process of government by which bills are considered and laws enacted is commonly referred to as the legislative process. So again, a bill has to be approved by both houses of the legislature before it's sent to the governor for final action. As a bicameral body, the California legislature is composed of the 80-member assembly and the 40-member Senate. And the legislature meets in 2-year sessions. Now, a bill is generally approved by a policy committee and often a fiscal committee in both houses. Once adopted by both houses, the bill is sent to the governor, who may veto it or sign it into law. And this process can take a few months or an entire 2-year legislative session or sometimes longer. Policy committees to consider the policy implications of proposed legislation, and the fiscal committees, which consider the fiscal impacts of proposed legislation, hear and consider and ultimately vote on legislation after gathering input from interested parties. As you can imagine, these types of bills come from ideas that are put forth by constituents, interest groups, legislative staff, and legislators themselves. And once a legislator decides to author a bill, he or she has the office of Legislative Counsel, or OLC, draft the bill for introduction. Thereafter, the legislator introduces the bill in the assembly, if it's an assembly member author, or in the Senate, if a senator is the author. The bill is assigned a bill number and read publicly for the first time. And then the respective rules committees in the Senate or the Assembly will assign the bill to one or more standing committees for consideration. There are a number of methods to track legislation throughout the legislative process, and there are numerous opportunities for members of the public to participate in this legislative process. Once the Rules Committee has assigned the introduced bill to a policy committee, then that bill is heard in a policy committee and possibly a fiscal committee if there are fiscal implications of that legislative measure. The proper committee referral is usually based upon the subject matter of the bill and the jurisdiction of the committee or committees. At this committee hearing, the author presents his or her bill, and the proponents and opponents are permitted to speak at the hearing as well. Bills are then considered in the policy committee in the House of Origin and most often in the fiscal committee. The majority of bills are referred to both a policy and a fiscal committee. And once the committee or committees consider the measure, then the bill goes to the floor of the Assembly or Senate, and once passed, must complete this same process in the other house. Now, throughout this process, there's several opportunities prior to and during these committee hearings for interested parties to express their views on pending legislation. Thereafter, the committee members debate the merits of the particular bill, and they vote to either pass or defeat the bill. The committee, of course, can amend the bill or pass it as introduced. Along the way, the bill's author can also amend his or her bill as necessary or desired. The committee staff prepares an analysis of the bill and its impact on existing law. It's important to express your viewpoints on legislation prior to committee hearing so that your views can be considered before legislators actually vote on the bill. They want to hear from constituents and interest groups regarding pending legislation and the implications for those measures. Now, as bills make their way through the legislative process, they may be amended either substantively or technically. And interested parties can and should track legislation throughout the legislative process and determine whether those amendments are favorable or unfavorable to one's position. Those amendments ultimately need to be agreed to by the House of Origin before the bill reaches the governor's desk. Bills are required to be read 3 times on the floor of both the Assembly and the Senate unless waived. The first reading occurs when the bill is introduced in the House of Origin and when it first arrives in the second house for consideration. The second reading occurs when it passes out of the first committee, either to another committee, such as the Fiscal Committee, or to the floor. The third reading occurs right before the measure is taken up on the floor for debate and a vote. Again, the same process occurs in the second house, that is Policy Committee, Fiscal Committee, floor debate, and vote. If there were any amendments made in the second house, then the bill must return to its house of origin for a final vote called a concurrence vote to either accept or reject those amendments. If they are rejected, then a 2-house conference committee is convened to resolve the differences, although this rarely occurs in modern times at the California legislature. If they are accepted, then the measure goes to the governor's desk. The governor generally has 12 days upon which to act on a measure, except for the large volume of bills that are sent to his or her desk at the end of session, in which case they generally have 30 days. And with those bills, usually numbering about 750, again, the governor has 30 days to sign or veto them. The governor also has the option to allow a bill to become law without his or her signature. The final step is a mechanical one in which the California Secretary of State assigns a chapter number to each bill that has been enacted and signed into law by the governor. So again, those are the basics of the California legislative process, basically how a bill becomes law in the California state legislature.